Hello everyone, welcome to Lecture 4 on Warranties, Premium, and Policy. A warranty is an affirmation of fact or a promise that forms part of the terms and conditions of the policy. Otherwise stated, a warranty is a statement or promise set forth in the policy or by reference incorporated therein, the untruth or non-fulfillment of which renders the policy voidable by the insurer. A warranty may either be express or implied, affirmative or promissory. As to the formalities of an express warranty, it must be contained in the policy itself or it may be expressed in another instrument, provided that the separate instrument is signed by the insured and referred to in the policy. An example of an express warranty is a statement in the life insurance policy that the insured has not been involved in any vehicular accident for the past 10 years or has never been charged with any crime involving moral turpitude. A breach of warranty by the insured renders the contract defeasible. However, in order to avoid the policy, the insurer must prove such breach consistent with the rule that any violation must be established by the person who is making such allegation. The insurer may elect to waive his right to avoid the policy in case of breach by the insured. This waiver may be express or implied. For example, there is implied waiver when the insurer renewed the policy knowing that there was breach of warranty. Also, a party may rescind the policy if there is breach of warranty on the part of the other party. Here are the distinctions of warranty and representation. While warranty is part of the contract, representation is not part of the contract but a collateral inducement. While warranty is written on a policy or its writer, representation can be oral or in writing. While warranty is presumed to be material, representation must be established to be material. And while there must be strict compliance in warranty, representation must only be substantially true. Now let's proceed to the important concepts on premium. The insurer is entitled to payment of the premium as soon as the thing insured is exposed to the peril insured against. Payment can be through delivery of cash to the insurer. It can also be through delivery of a check, subject to the rule that delivery of a check is not deemed payment until it is encashed or cleared and credited to the account of the insurer. The obligation of the insurer will not become valid and binding if the first premium has not been paid. Considering that the insurance contract is consensual, a juridical bond already exists between the parties the moment the contract is perfected by mere consent. However, the obligation of the insurer is subject to the condition that the premium is paid. The following are the instances wherein the insurance contract is still binding, even if the premium is unpaid. When the grace period applies in case of life and industrial life policy, when there is an acknowledgement in the policy or receipt that the premium has been paid, when there is an agreement that the premiums shall be payable on installment, when there is a credit extension, and when the equitable doctrine of estoppel applies. Now let's proceed to the important concepts on policy. Although formalities are not required for the perfection of the contract, it is still mandated by law that written policies should be issued by the insurer. A policy of insurance must specify the following: the parties between whom the contract is made, the amount to be insured except in the cases of open or running policies, the premium, or if the insurance is of a character where the exact premium is only determinable upon the termination of the contract, a statement of the basis and rates upon which the final premium is to be determined, the property or life insured, the interest of the insured in property insured, if he is not the absolute owner thereof, the risk insured against, and the period during which the insurance is to continue. As to the interpretation of the terms of the policy, if such terms are clear and unambiguous, they must be taken and understood in their plain, ordinary, and popular sense. If, however, there is doubt, any doubt should be resolved against the insurer, since an insurance contract is a contract of adhesion. Conformably, it stands to reason that the doubt should be resolved against the insurer, whose lawyer or managers drafted the insurance policy contract. Take note also of the cancellation and rescission grounds, which are enumerated in the insurance code. However, it may also happen that what was agreed upon is different from what is written in the policy. In such case, the court would have the power to reform the contract and give effect to it in the sense in which the parties intended to be bound. So that's it for today's lecture. Thank you so much for listening.